I woke up that Tuesday morning to find a construction crew drilling into my ridge, and by the time I got my boots on, they had already poured concrete footings for what looked like a massive gazebo. The ridge was my property. I had the survey markers and deed to prove it, but apparently, the Meadowbrook Hills HOA decided they knew better. My name is Xavier Lawson, and I have owned this 3-acre plot in rural Virginia just outside of Charlottesville for 8 years. The ridge they were building on was the highest point of my land, offering views of the Blue Ridge Mountains that I had spent thousands of dollars preserving when I bought the place. I had specifically chosen this property because it sat on the edge of the HOA boundaries, thinking I would have some breathing room from their endless regulations and power trips. I marched down the hill in my work clothes, still holding my morning coffee, and approached the foreman. He was a stocky guy in his 50s with a weathered face and a clipboard that he clutched like a shield. "Excuse me," I said, keeping my voice level despite the anger bubbling in my chest. "What exactly are you building on my property?" The foreman looked up from his clipboard with genuine confusion. "Your property? We were told this was HOA common land. We have permits and everything." He flipped through his papers and showed me a work order signed by someone named Patricia Hendricks, HOA president. The address listed was indeed close to mine, but the lot number was wrong. It was my lot number, but they had written it down as if it belonged to the HOA. "This is lot 47, I said, pointing to the survey marker just 10 feet away. "My lot. I can show you the deed right now." "That lot number on your work order is mine, not HOA common property." The foreman's face went pale. He pulled out his phone and made a call, stepping away from me to speak in hushed tones. I could hear fragments of his conversation, words like mistake and need to verify floating back to me. After about 5 minutes, he returned with an apologetic expression. "Look, sir, I am going to need to verify this with the HOA. They hired us and they are paying us. Until I hear otherwise from them, I have to continue the work. I have got a crew here and we are on a schedule." "Then I am calling the sheriff," I said flatly, "because you are trespassing and destroying my property." I went back to my house and did exactly that. The sheriff's deputy who arrived an hour later was a young guy named Morrison, who I had seen around town. He looked over my deed, walked down to check the survey markers, and then examined the HOA's work order. "Mr. Lawson, you are clearly in the right here," he said. "This is your property according to county records. However, this is a civil matter. I can tell them to stop work, but the HOA will need to resolve this through proper channels." Deputy Morrison went down and spoke with the foreman, and the construction crew packed up their equipment. But the damage was already done. They had drilled 4 concrete footings into my ridge, each one about 3 feet deep. The beautiful natural grass and wildflowers that had covered that spot were torn up, replaced by industrial scars. I immediately drove to the HOA office, which was located in a small building near the neighborhood entrance. The office was decorated like someone's grandmother's living room, with floral wallpaper and uncomfortable-looking chairs. Behind the desk sat a woman in her late 40s with blonde hair styled in that particular way that suggested she had asked to speak to many managers in her lifetime. Her nameplate read, "Patricia Hendricks, HOA president." "Mr. Lawson," she said when I walked in, her voice dripping with false sweetness. "I assume you are here about the gazebo project. You mean the gazebo you are trying to build on my private property," I said. "Yes, that gazebo." Patricia folded her hands on her desk and gave me a smile that did not reach her eyes. "According to our records, that ridge is part of the Common Area Amenities Package. When the development was first planned, certain elevated viewpoints were designated for community use. Then your records are wrong, I said, slapping my deed down on her desk. This is my land. I have the county records, the survey, everything. You do not have any right to build anything there. She barely glanced at the deed. I will have our attorney review this. In the meantime, the gazebo project is approved by the board and will proceed once we clear up this little misunderstanding. There is no misunderstanding, I said, my voice rising. You are trespassing. The sheriff has already been out there. Your construction crew has already done damage to my property. You need to remove those concrete footings and restore my land. Patricia's fake smile vanished. Mr. Lawson, I suggest you watch your tone. This HOA has certain rights and responsibilities to maintain property values and community standards. If you continue to be difficult, we may need to consider other options. Other options, I said. Are you threatening me? I am simply stating facts, she said coolly. Now, if you will excuse me, I have other matters to attend to. I left the office furious. Over the next 3 days, I sent certified letters to the HOA board, emailed copies of my deed and survey, and even paid my attorney $300 to send a formal cease and desist letter. The HOA's response was radio silence. Then, that Saturday morning, the construction crew returned. I was in my garage working on my truck when I heard the sound of heavy equipment. I ran down to the ridge and found the same crew, now with additional workers, actively building a large octagonal gazebo. The concrete footings I had seen before were now supporting wooden posts, and they were framing out the roof structure. "What the hell are you doing?" I shouted at the foreman. "I told you this is my property." The foreman would not even look at me. "I've got my orders from the HOA. They said the legal issues are resolved and we are clear to proceed." "They are lying," I said. "Nothing is resolved." One of the workers, a younger guy with tattoos covering his arms, stepped forward. "Look, man, we are just doing our jobs. Take it up with whoever hired us." I pulled out my phone and called Deputy Morrison again. This time, he sounded less sympathetic. "Mr. Lawson, I told you this is a civil matter. You need to handle this through the courts or your attorney. I cannot keep coming out here to referee property disputes." "They are actively building on my land without permission," I said. "That is trespassing and destruction of property." "And they claim they have permission from the HOA," Morrison said. "Without a court order or injunction, my hands are tied. File a lawsuit if you want them to stop." I called my attorney, a local guy named Robert Finch who handled real estate issues. He confirmed what Morrison had said. "Xavier, you are absolutely in the right, but stopping active construction requires an emergency injunction. I can file the paperwork Monday morning, but it will take a few days to get a hearing. In the meantime, they can keep building unless you want to take matters into your own hands, which I strongly advise against." But taking matters into my own hands was exactly what I was considering. I watched the construction crew work through Saturday and Sunday, building what was clearly going to be an expensive, elaborate gazebo right on the best viewpoint of my property. They worked from 7 in the morning until 6 at night, and by Sunday evening, the structure was nearly complete. It had a beautiful cedar roof, decorative railings, and built-in benches. Under other circumstances, I might have admired the craftsmanship. But all I could see was a monument to the HOA's arrogance and disrespect for property rights. Monday morning, I met with Robert Finch at his office in downtown Charlottesville. He had already drafted the injunction paperwork and filed it with the court. "The hearing is set for Thursday," he said. "Judge Matthews is handling it. She is fair and knows property law well. But Xavier, I have to warn you, this is going to cost money. Court fees, my time, possibly expert witnesses if they contest the survey. We are looking at several $1,000s minimum. I do not care about the money, I said. I care about them thinking they can just take my land. I understand, Robert said. But there is something else you should know. I did some digging into the HOA's history. Patricia Hendricks has been president for 6 years, and there have been multiple complaints filed against the HOA for overreach and improper enforcement of rules. Nothing that went anywhere legally, but a pattern of behavior. She runs that HOA like her personal fiefdom. That evening, I walked down to the ridge to examine the completed gazebo. It was actually finished. They had worked through Monday while I was at Robert's office. The structure was impressive, about 20 feet in diameter with that octagonal cedar roof and thick support posts. They had even installed solar-powered lights and a small plaque that read, Meadowbrook Hills Community Gazebo ESD, 2026. Looking at it made my blood boil. I took detailed photographs from every angle, documenting how it sat on my property, how it blocked my view, how the construction had torn up the natural landscape. Then, I went back to my house and spent the evening researching Virginia property law and HOA regulations. What I found was interesting. While HOAs in Virginia had broad powers, they could not simply seize private property for community use. There were specific procedures involving compensation, easements, and legal agreements. The HOA had followed none of them. Tuesday morning, I received a letter from the HOA. It was not an apology or an acknowledgement of their mistake. Instead, it was a bill for $1,500 as my share of the gazebo construction costs. The letter, signed by Patricia Hendricks, explained that all homeowners were being assessed for this community enhancement project, and payment was due within 30 days. I actually laughed when I read it. They had built an unauthorized structure on my private property and were now billing me for it. The audacity was almost impressive. I scanned the letter and sent it to Robert Finch with a note. "You are not going to believe this." He called me within an hour. "This is actually good for us," he said. "It shows they are claiming ownership and authority over property they do not own. It strengthens our case. Do not pay that bill." Wednesday afternoon, I was working from home when I heard voices down by the gazebo. I looked out my window and saw Patricia Hendricks giving what appeared to be a tour to several people. They were walking around the gazebo, taking pictures, and Patricia was gesturing enthusiastically. I grabbed my jacket and headed down there. As I approached, I could hear Patricia talking. "And this will be available for all residents to reserve for private events. Weddings, birthday parties, family gatherings. We are thinking a nominal $50 reservation fee to cover maintenance costs." "Excuse me," I said loudly. "What exactly do you think you are doing?" Patricia turned to me with that same fake smile. "Mr. Lawson, I was just showing some board members our newest community amenity. Is there something I can help you with?" "Yes," I said. "You can get off my property, all of you." One of the board members, an older man with white hair, looked confused. "Patricia, I thought you said this was common property." "It is," Patricia said smoothly. "Mr. Lawson here has some confused ideas about property lines, but our attorney is handling it." "Your attorney is going to tell you the same thing my attorney and the county records and the sheriff already told you," I said. "This is my land. That gazebo is on my property without my permission, and you are all trespassing right now." The board members exchanged uncomfortable glances. Patricia's smile finally cracked. "Mr. Lawson, you are being incredibly selfish about this. This gazebo benefits the entire community. Property values will increase. People will have a beautiful space to gather. Why are you being so difficult?" "Because it is my property," I said. "Do you not understand basic property rights? You cannot just take someone's land because you think it would be nice for the community. We are not taking anything, Patricia said. We are developing an underutilized space for the benefit of all residents. On my land, I repeated. Without my permission. That is called theft. The board members were looking very uncomfortable now. One of them, a middle-aged woman with red hair, spoke up. Patricia, maybe we should wait until the legal issues are resolved before we start showing this off. The legal issues are nonsense, Patricia snapped. I have been president of this HOA for 6 years. I know what property we control. Apparently you do not, I said. I will see you all in court on Thursday. Thursday morning arrived and I met Robert Finch at the Albemarle County Courthouse. Judge Sarah Matthews presided over a surprisingly full courtroom apparently. Property disputes drew an audience in Charlottesville. Patricia Hendricks was there with the HOA's attorney, a slick-looking guy in an expensive suit named David Monroe. The hearing was straightforward. Robert presented my deed, the county survey records, and the survey markers on the property. He showed photographs of the gazebo's location and cross-referenced it with the official plat map. It was clear, undeniable proof that the gazebo sat entirely on my private property, specifically Lot 47. David Monroe tried to argue that there was an ambiguity in the original development plans, that some early sketches had shown the ridge as common property, and that the HOA had operated under a good faith belief that they owned the land. Judge Matthews was not impressed. Mr. Monroe, she said, beliefs do not supersede recorded deeds and surveys. The county records are clear. This is Mr. Lawson's property. The HOA has built a structure on private land without the owner's permission. Your Honor, Monroe said, my client is willing to work out a compromise. Perhaps an easement arrangement or a purchase agreement. I do not want a compromise, I said before Robert could stop me. I want my property restored. Judge Matthews looked at me. Mr. Lawson, you will have your chance to speak through your attorney. Mr. Finch, Robert stood. Your Honor, my client has made his position clear. He wants the unauthorized structure removed and his property restored to its original condition. Judge Matthews nodded and made some notes. Then she delivered her ruling. I am granting an immediate injunction prohibiting the Meadowbrook Hills HOA from any further construction or development on Lot 47. Furthermore, the HOA is ordered to remove the gazebo structure within 30 days and restore the property to its natural state. Mr. Lawson, you will need to file a separate civil suit for damages if you wish to pursue compensation for the unauthorized construction. Patricia Hendricks actually gasped. David Monroe tried to argue for more time, but Judge Matthews was firm. 30 days, Mr. Monroe. That is generous considering your client built this structure knowing there was a property dispute. As we left the courtroom, Patricia caught up with me in the hallway. Her face was red with anger. You are making a huge mistake, she said. This HOA controls your life in ways you do not even realize. Your property values, your resale potential, your daily living conditions. We can make your life very difficult. Are you threatening me again? I asked, and this time Robert was there to witness it. I am simply stating facts, Patricia said, echoing her earlier words. You have made an enemy of this HOA, Mr. Lawson. You will regret it. That sounded like a threat to me, Robert said, and I am a witness. You might want to be more careful about what you say, Miss Hendricks. Patricia turned and stormed off, her heels clicking angrily on the courthouse floor. Robert turned to me. Xavier, she was not kidding about making trouble. HOAs can be vindictive. They will probably start citing you for every tiny violation they can find. Let them try, I said. I follow the rules. The 30-day deadline came and went. The gazebo remained exactly where it was. I sent a certified letter to the HOA on day 31, reminding them of the court order. No response. On day 35, I called David Monroe's office. His secretary told me he was no longer representing the HOA. Apparently, Patricia had fired him for losing the case. On day 40, I filed a motion for contempt of court. Judge Matthews scheduled a hearing for the following week. When that day arrived, Patricia showed up without an attorney. She told the judge that the HOA was working on removing the gazebo, but had faced logistical challenges in finding a contractor willing to dismantle it. Judge Matthews was not amused. "Miss Hendricks, you had 30 days. It is now day 47. The gazebo should have been removed over 2 weeks ago. I am holding the HOA in contempt and imposing a fine of $500 per day until the structure is removed." Patricia turned pale. "Your Honor, the HOA does not have that kind of money in reserves." "Then I suggest you remove the gazebo quickly," Judge Matthews said. "And Miss Hendricks, if you appear before me again without legal representation, I will consider it disrespectful to this court." Another week passed. The gazebo remained. The HOA was now accruing $3,500 per week in contempt fines. I drove by the HOA office and saw Patricia's car there late into the evening several nights in a row. Clearly, she was dealing with a crisis. Then I received a visit from 2 other board members, the older man with white hair and the red-haired woman from before. They introduced themselves as George Pemberton and Linda Walsh. They looked exhausted. "Mr. Lawson," George said, "we need to talk. May we come in?" I let them into my living room. Linda spoke first. "We want you to know that most of the board did not know about the gazebo project until it was already underway. Patricia handled everything herself. She told us it was approved and on HOA property." "And you did not verify that?" I asked. George shook his head. "We trusted her. She has been president for years and usually knows what she is doing. But this time, she made a huge mistake. The HOA is facing over $10,000 in contempt fines now, plus we will owe you damages. Our reserves are nearly depleted." "Why are you telling me this?" I asked. "Because we cannot get Patricia to remove the gazebo," Linda said. "She keeps saying she is working on it, but nothing happens. We think she is in denial about losing. The rest of the board wants to remove her as president, but she has allies who are blocking it." "So you want my help?" I asked. "We want to remove the gazebo," George said, "but we need more time to organize it properly and get bids from contractors." "Could you ask the judge for an extension on the deadline?" "We will get it done, I promise." I thought about it. These 2 seemed genuine and they were clearly trying to fix Patricia's mistake, but I was also tired of waiting. "I will think about it," I said, "but I want regular updates. If I am going to help you, I need to see actual progress." They agreed and left me their contact information. Over the next few days, Linda sent me emails with contractor quotes and timelines. They were genuinely trying to solve the problem. But then, Patricia found out about their communications with me. I received an angry email from Patricia accusing me of colluding with rogue board members to undermine HOA leadership. She claimed that George and Linda had no authority to negotiate with me, and that all communications should go through her as president. The email ended with another thinly veiled threat about HOA enforcement actions against my property. That was when I decided I was done waiting for the HOA to fix their mess. They had over 50 days since the court order. The gazebo was still standing on my ridge, mocking me every time I looked out my window. The HOA was imploding with internal politics and Patricia's ego. and I was paying Robert Finch thousands of dollars to file motions and attend hearings while nothing actually changed. So on a Saturday morning in early May, I drove to a tool rental place in Charlottesville and rented a reciprocating saw, a sledgehammer, and a heavy-duty drill. I loaded them into my truck along with my own tools, work gloves, safety glasses, and a cooler full of water and sandwiches. Then I drove home and got to work. The gazebo was well built, which made it harder to dismantle. I started with the roof, climbing up and carefully removing the cedar shingles. I stacked them neatly on the ground, working methodically. Each shingle came off cleanly, and I organized them by size. Then I moved to the roof framing, using the reciprocating saw to cut through the bolts and fasteners holding the beams together. The octagonal frame came apart in sections, each piece of cedar heavy and solid. By noon, the roof was completely dismantled and stacked in neat piles. I took a break, ate a sandwich, and admired my progress. Then I started on the railings and built-in benches. These were attached with heavy-duty lag bolts that required the drill to remove. Each piece of railing was crafted from beautiful wood with decorative spindles. Under other circumstances, it would have been a shame to take it apart, but they had built it on my property without permission, so down it came. The support posts were the hardest part. They were anchored into those concrete footings with massive bolts and brackets. I used the sledgehammer to break the brackets, then the reciprocating saw to cut through the bolts. Each post was at least 8 inches in diameter and 12 feet tall. As each one came free, I carefully lowered it to the ground and added it to my growing piles of materials. By 6 in the evening, the entire gazebo was dismantled. All that remained were the concrete footings sticking up from my ridge like broken teeth. Those would require professional equipment to remove properly, but the structure itself was gone. I had organized all the materials into careful stacks. The cedar shingles in one pile, the roof beams in another, the railings and decorative elements in a third, the support posts in a fourth, and all the hardware and fixtures in buckets. Then came the satisfying part. I loaded everything into my truck, making multiple trips because there was so much material. I drove each load down to the HOA office entrance, which was at the main gate of Meadowbrook Hills. It was after hours, so the office was closed and the parking lot was empty. I unloaded every piece of the gazebo right in front of the main entrance, creating a substantial barrier that would be impossible to miss. I stacked the materials neatly and carefully. The support posts went first, creating a foundation. Then the roof beams, arranged in a geometric pattern. The railings and decorative pieces went next, stacked artfully. The cedar shingles I arranged in overlapping rows, creating a wall of wood. Finally, I placed the buckets of hardware on top, along with the plaque that had read Meadowbrook Hills Community Gazebo ESD 2026. When I was finished, I had created an impressive installation that completely blocked the HOA office entrance. You could not walk through the front door without climbing over 8 feet of stacked gazebo materials. I took photographs of my work from multiple angles, documenting the artistic arrangement of cedar and hardware. Then I drove home, exhausted but deeply satisfied. Sunday morning, my phone started ringing at 7. It was George Pemberton. "Xavier, what did you do? Patricia is losing her mind. She called an emergency board meeting and is talking about filing criminal charges against you." "I dismantled an unauthorized structure from my property," I said calmly. "Then I returned the materials to their owner. What is the problem? You blocked the entire office entrance." "I had a lot of materials to return," I said. "They built a big gazebo. Where else was I supposed to put it?" George made a frustrated sound. "Look, I understand why you are angry, but this is not helping. Patricia is using this as proof that you are unreasonable and vindictive. She is rallying board members against you. She had 50+ days to remove it herself, I said. Judge Matthews gave clear orders. The HOA ignored them, so I solved the problem myself. You could be charged with destruction of property, George warned. It was on my property, I said. I have a court order saying the HOA built it illegally. I have documentation of every attempt to get them to remove it. I am not worried. I was not entirely truthful about that last part. After I hung up with George, I did call Robert Finch to give him a heads up about what I had done. There was a long silence on the other end of the line after I explained. Xavier, he finally said, I understand your frustration, but you have potentially opened yourself up to legal problems. They could argue destruction of property, vandalism, even dumping. How is it dumping when I return their materials to them? I asked. Because you deliberately blocked their entrance, Robert said. That could be considered harassment or creating a public nuisance. Their gazebo on my property was not a public nuisance, I asked. Look, we are on solid legal ground with the original case, Robert said. You own the property, they built on it illegally. The judge agreed with us. But taking apart the structure yourself instead of letting them do it or getting court enforcement, that is a gray area. And doing it in a way that blocks their office entrance, that is harder to defend. So what do you think will happen? I asked. Honestly, I think they will move the materials and grumble about it. Filing charges against you would just draw more attention to the fact that they violated the court order for 50 days. But Xavier, do not do anything else without talking to me first, okay? I agreed, but I was not actually worried. What I had done felt right. They had ignored court orders, accumulated thousands in fines, and showed no sign of taking responsibility for their actions. Someone had to force the issue. Monday morning, I drove past the HOA office on my way to work. The materials were still there, untouched. Cars were parking in other spots, and people were entering the building through a side door. The stack of gazebo pieces stood like a monument in the morning sun. By Monday afternoon, Patricia had filed a police report. Deputy Morrison called me. Mr. Lawson, I need you to come down to the station and give a statement about what happened at the HOA office. I drove to the sheriff's office with copies of the court order, photographs of the gazebo on my property, and documentation of my communications with the HOA. Deputy Morrison reviewed everything carefully. He called in his supervisor, Sergeant Daniels, who also looked through all my materials. Mr. Lawson, Sergeant Daniels said, I am going to be straight with you. What you did was legally questionable, but I understand why you did it. The HOA built on your property illegally, ignored a court order, and accumulated substantial fines. You removed the structure from your property, which you had a right to do. Where you returned the materials is the sticky part. I gave them back to their owner, I said. Where else should I have put them? Literally anywhere else, Daniels said. Your driveway, the curb in front of your house, a storage facility. By blocking their entrance, you created a problem. So what happens now? I asked. Patricia Hendricks wants us to charge you with vandalism and harassment, Daniels said. But given the circumstances and the court order they violated, I do not think those charges would go anywhere. What I am going to recommend is that you move those materials within the next 24 hours. Put them somewhere on HOA common property that does not block any entrances or access points. Can you do that? I can, I said. But I want it noted that I was returning property that was illegally placed on my land. It will be noted, Daniels said. But Mr. Lawson, let the courts handle this from now on. Taking matters into your own hands just complicates things. That evening, I rented a truck and recruited my neighbor, a guy named Tim who lived 2 properties over and had no love for the HOA himself. He had been cited multiple times for things like having his trash cans visible from the street and parking his boat in his driveway. We loaded up all the gazebo materials from the HOA office entrance and drove them to a grassy common area near the neighborhood pool. We stacked everything neatly on the lawn, well away from any walkways or entrances. It took 3 trips and most of the evening, but we got it done. "Man," Tim said as we finished, "I wish I had the guts to do what you did. That was legendary." "It might end up costing me," I said. "But it felt good." The next few days were relatively quiet. The HOA materials sat on the common area lawn, slowly weathering in the spring rain. Nobody moved them. I focused on my work and tried to let the legal process handle things. Robert Finch filed paperwork seeking compensation for the property damage to my ridge and reimbursement of legal fees. The contempt fines against the HOA had now exceeded $20,000. Then, Patricia made her next move. I received a violation notice in the mail citing me for exterior paint that does not conform to HOA standards. My house was painted a light gray color that had been approved when I bought the property 8 years ago. The notice claimed the paint had faded and discolored and needed to be repainted within 30 days in a color from the approved palette. I took photographs of my house from every angle. The paint looked fine, no fading or discoloration. I checked the HOA rules and found that exterior maintenance was only required when paint was visibly peeling, cracked, or substantially faded. My paint had none of those issues. This was clearly retaliation. 2 days later, another notice arrived. This one cited me for unapproved landscaping modifications. The notice claimed I had planted bushes near my driveway without HOA approval. Those bushes had been there when I bought the house 8 years ago. I had photographs from my original purchase to prove it. The third notice arrived on Friday. This one cited me for improperly stored vehicle because my truck was visible from the street. My truck was parked in my driveway, where vehicles were explicitly allowed according to the HOA rules. The notice claimed that because my truck had work equipment visible in the bed, it constituted a commercial vehicle that required special parking. I forwarded all 3 notices to Robert Finch. He called me within an hour. "This is textbook retaliation," he said. "Patricia is throwing everything she can at you hoping something sticks. We can fight all of these, and when we do, it will strengthen our overall case that the HOA has been acting in bad faith." "How much is this going to cost me?" I asked. "We can probably handle all 3 violations in one motion," Robert said. "Maybe another $1,500 in legal fees. But Xavier, here is the thing. Every action Patricia takes is digging the HOA deeper. At some point, the rest of the board is going to realize she is destroying them financially." That point came sooner than expected. The following Tuesday, I received an email from Linda Walsh with the subject line, "Board Changes." The email explained that the HOA board had held a special vote and removed Patricia Hendricks as president. George Pemberton was now acting president. Patricia remained on the board but had no special authority. The email continued, "We want to resolve the ongoing dispute with you as quickly and fairly as possible. The board has authorized payment of all outstanding contempt fines to the court. We are also prepared to offer you compensation for the damage to your property and reimbursement of your legal fees. Could we schedule a meeting to discuss terms?" I called Robert Finch and read him the email. "That is great news," he said, "but we need to be careful about the settlement terms. Do not agree to anything without me reviewing it first. The meeting was scheduled for Thursday evening at the HOA office. I arrived with Robert to find George, Linda, and 3 other board members waiting in the conference room. Patricia was notably absent. George explained that they had decided it was better if she did not attend, given the contentious history. "Mr. Lawson," George began, "first, I want to apologize on behalf of the board. What happened with the gazebo should never have occurred. Patricia acted without proper authorization and ignored multiple warnings from board members and our attorney. We take full responsibility." "I appreciate that," I said, "but apologies do not fix my property." "We know," Linda said. "That is why we are prepared to offer you $25,000 in compensation. That includes the cost of removing the concrete footings, restoring the natural landscaping, reimbursing your legal fees, and additional compensation for your time and frustration." Robert and I exchanged glances. It was actually a generous offer, more than we had calculated in damages. "What else?" Robert asked, because there was always something else. "We need you to drop the violation notices Patricia issued," George said. "We have already canceled them internally, but we need your formal acknowledgement that they are resolved." "Done," I said. "What else?" "And we would like your assurance that you will not pursue further legal action against the HOA," Linda added. "We have paid the contempt fines. We are offering compensation. We are removing the concrete footings at our expense, and we are restoring your property. In exchange, we need this matter closed." Robert spoke before I could. "We will agree to those terms with one addition. The settlement agreement needs to include language prohibiting any retaliatory actions against Mr. Lawson in the future. No manufactured violations, no selective enforcement, no harassment." The board members discussed this quietly among themselves. Finally, George nodded. "We can agree to that. We will draft the settlement with all these terms and have it to you by next week." True to their word, the settlement agreement arrived the following Tuesday. Robert reviewed it carefully and suggested a few minor changes, which the HOA accepted. By the end of May, the agreement was signed and I received a check for $25,000. The HOA hired a contractor to remove the concrete footings from my ridge. It took a full day of work with heavy equipment, but they got it done. Then a landscaping company came and restored the natural grasses and wildflowers. By mid-June, my ridge looked almost like the gazebo had never been there. There were still some scars in the earth, but nature was already beginning to reclaim the space. The materials from the gazebo remained on the common area lawn for another 3 weeks before the HOA finally dealt with them. They held a community yard sale and sold off the cedar pieces to residents for various projects. The remainder was donated to a local charity that built community structures. Even dismantled and scattered, that gazebo was causing administrative headaches for the HOA. As for Patricia Hendricks, her reign of terror was effectively over. She remained on the board, but other members now outvoted her on every issue. At the next annual HOA meeting, she ran for president again and lost badly. Several residents stood up during the meeting and voiced complaints about her leadership style and the financial damage from the gazebo incident. She resigned from the board entirely 2 months later. I heard through the neighborhood grapevine that Patricia moved out of Meadowbrook Hills about 6 months after the gazebo incident. She sold her house and relocated to another development in Lynchburg. George Pemberton told me later that she had trouble selling because word had gotten around about her role in the HOA disaster, and potential buyers were concerned about property values. The total cost to the HOA from Patricia's gazebo project was staggering. Over $20,000 in contempt fines paid to the court, $25,000 in settlement to me, approximately $15,000 for construction of the gazebo, another $8,000 for removal and property restoration, and probably another $10,000 in legal fees for various attorneys they hired and fired. Over $75,000, because Patricia decided she knew better than the county records and property deeds. The HOA had to levy a special assessment on all residents to cover the costs. Every homeowner in Meadowbrook Hills paid an extra $500 that year because of Patricia's arrogance. That did not make me popular with some neighbors, though most understood I was not at fault. Tim next door actually brought me a six-pack of beer and thanked me for taking down the tyrant. My ridge is peaceful now. The wildflowers have fully returned, and the grass has grown thick and healthy. I still have the best view of the Blue Ridge Mountains in the entire development. On clear mornings, I take my coffee down there and watch the sunrise over the peaks. No gazebo, no construction equipment, no HOA president telling me what I can do with my own land. The experience taught me some valuable lessons about property rights and HOA disputes. First, document everything. I had photographs, emails, certified mail receipts, and detailed records of every interaction. That documentation was crucial in court and in the final settlement. Second, know your property boundaries. I had my deed and survey readily available, which made it impossible for the HOA to claim confusion or ambiguity. Third, get legal help early. Robert Finch was expensive, but his guidance protected me from making mistakes that could have weakened my case. But the most important lesson was about standing your ground when you are right. The HOA counted on me backing down, accepting their version of property boundaries, or being too intimidated to fight back. Patricia Hendricks was used to people giving in to her demands. When I refused, it exposed the weakness in her position and eventually brought down her entire power structure. I am not saying everyone should dismantle unauthorized structures and stack them at the HOA office entrance. That was risky and could have gone badly. But the principle behind it, refusing to accept illegal actions just because they come from an authority figure, that is important. Property rights mean something. Deeds and surveys exist for a reason. When someone violates those rights, even with good intentions or claims of community benefit, they need to be held accountable. Robert Finch told me later that my case became somewhat famous in local real estate law circles. He said other attorneys were using it as an example of HOA overreach and the importance of proper due diligence before community construction projects. Judge Matthews apparently mentioned it in a later ruling involving a different HOA dispute. In her words, community associations must respect individual property rights and cannot simply appropriate private land for public use, regardless of the perceived benefit to the community. The new HOA board under George Pemberton's leadership was noticeably different from Patricia's regime. They sent out quarterly newsletters with transparent financial information. They held open board meetings where residents could voice concerns. They created a formal review process for any construction or modification projects to ensure proper legal authorization. Basically, they started running the HOA like a legitimate community organization instead of Patricia's personal kingdom. I even attended a few board meetings after the settlement, just to keep an eye on things. At one meeting, a resident proposed building a community garden on what she thought was common property. George immediately called for a survey verification before any discussion proceeded. He looked at me and said, "We learned that lesson the hard way." Everyone in the room laughed, including me. My relationship with the HOA is civil now, if not warm. I follow the rules, they leave me alone. I paint my house when the paint actually needs it. I keep my lawn maintained according to the covenants. I do not give them any legitimate reasons to cite me for violations. And they, in turn, do not manufacture fake violations to harass me. The settlement agreement's prohibition on retaliatory actions has been honored. Tim next door was not as lucky. The new board was better than Patricia's, but they were still an HOA with rules to enforce. He got cited again for his boat in the driveway, and eventually had to build a storage shed in his backyard. But even he admitted the new board was more reasonable about deadlines and worked with him to find a solution instead of just threatening fines. Looking back on the whole experience, I do not regret any of my actions, including the gazebo dismantling. Some people thought I went too far, that I should have been more patient and let the legal system work. But the legal system was working incredibly slowly, and the HOA was actively defying court orders while accumulating fines they might never pay. Sometimes you need to force the issue. Was it risky? Absolutely. Could it have ended badly for me? Definitely. Sergeant Daniels was right that blocking the HOA entrance was legally questionable. If Patricia had been more politically savvy, she might have used my actions to paint me as the unreasonable party. But she was not savvy. She was arrogant. She assumed she could just power through with accusations and threats. That approach failed because my fundamental position was legally unassailable. It was my property, documented and surveyed, and they had no right to build there. The gazebo itself was actually beautiful. If they had asked permission, offered to lease the land or purchase an easement, things could have been very different. I might have considered it. The view from that ridge is spectacular, and sharing it with the community was not an inherently bad idea. But they did not ask. They just took, assuming I would go along with it once the structure was built. That assumption was their downfall. I still see some of the former board members around the neighborhood. Linda Walsh waves when she drives past. George Pemberton stops to chat occasionally. Neither of them blames me for what happened, and both have said privately that the gazebo incident was the wake-up call the HOA needed. Years of unchecked authority under Patricia's leadership had created a culture where property rights and proper procedures were treated as inconvenient obstacles rather than fundamental principles. The special assessment to cover the HOA's costs from the incident was actually voted down at first. Residents were angry about having to pay for Patricia's mistakes, but George explained that the HOA's insurance did not cover willful violations of court orders, and the reserves were depleted. It was either a special assessment or monthly dues would triple for years to come. The residents grudgingly approved the assessment, but several people mentioned they would be carefully watching the board from now on. As I sit here on my ridge this evening, watching the sun set over the Blue Ridge Mountains, I feel a sense of hard-won peace. The wildflowers are blooming, purple and yellow dotting the green grass. A hawk circles overhead, riding the thermal currents. There is no gazebo blocking my view, no construction equipment tearing up the landscape, no HOA president telling me I am wrong about my own property boundaries. The fight was exhausting and expensive and stressful. There were days I wondered if it was worth it over a piece of land and a wooden structure, but it was never really about the gazebo. It was about whether individuals have rights that cannot be overridden by collective decisions or bureaucratic convenience. It was about whether recorded deeds and property surveys mean anything. It was about whether someone could simply take what was mine because they decided it would be better used for community purposes. And the answer, validated by Judge Matthews and eventually by the HOA itself, was no. They could not take my land. They could not ignore court orders. They could not bully me into accepting their version of reality. In the end, property rights won, the rule of law prevailed, and the tyrant fell from power. Some neighbors still think I was too aggressive in my response, but many others have quietly thanked me for standing up to the HOA. Apparently, Patricia had been making other people's lives difficult for years with petty violations and power trips. My fight became symbolic of broader frustrations with HOA overreach. One resident told me, "You did what a lot of us wanted to do but were too scared to try." That is both gratifying and sad. People should not be scared of their homeowners association. These organizations are supposed to maintain property values and provide community services, not terrorize residents with arbitrary enforcement and illegal land grabs. The fact that so many people felt intimidated by Patricia says something troubling about how HOAs can drift from their intended purpose. The concrete footings that were removed from my ridge left marks that are still visible if you know where to look. 4 circles of disturbed earth where the grass has not quite grown back the same. In a year or two, those marks will fade completely, and there will be no evidence the gazebo ever existed. But I will remember, and the HOA board will remember. And hopefully, the next time someone proposes a community project, they will verify property ownership first. My final legal bill from Robert Finch was reimbursed by the HOA settlement, but it was still shocking to see the total: $18,000 in attorney fees. That is what it costs to defend my property rights against an HOA with bad leadership and worse judgment. If I had not been able to afford that, or if I had not pushed back at every stage, the gazebo would still be standing on my ridge and Patricia would still be president, empowered by the precedent that she could take private property without consequences. That thought bothers me. How many people lose battles with their HOAs not because they are wrong, but because they cannot afford the legal fight? Property rights should not depend on your ability to pay attorney fees. The system is supposed to protect individuals from overreach, but it is expensive and slow. I got justice eventually, but it required resources and determination that not everyone has these days. I have a better relationship with my survey markers. I check them periodically to make sure they are still in place and clearly visible. I keep my property deed in a fireproof safe along with the settlement agreement and the court orders. I maintain digital and physical copies of everything, backed up in multiple locations. Maybe that is paranoid, but the gazebo incident taught me that you can never have too much documentation when it comes to property disputes. The HOA has not bothered me with any violation notices since the settlement. My house paint is fine, my landscaping is fine, my truck in the driveway is fine. Everything that was supposedly a violation before is somehow acceptable now. Funny how that works when there is a legal agreement prohibiting retaliatory enforcement. I have thought about writing up my experience and posting it online. Maybe it would help other people facing similar HOA disputes. But I worry about the attention it might bring. The neighborhood has finally settled down, and I do not want to stir things up again. This story will remain just a story, shared among local attorneys and whispered about at neighborhood barbecues. Tim next door asked me once if I would do anything differently. I thought about it for a while before answering. I would have documented the construction in more detail, I said. Taken video of them pouring the footings, got closer shots of the equipment and workers, recorded conversations. And I probably should not have blocked the HOA entrance with the materials, even though it felt great at the time. Would you still take apart the gazebo yourself? Tim asked. Absolutely, I said without hesitation. They had plenty of time and warnings. At some point, you have to act. The seasons have changed twice since the gazebo came down. 2 summers, 2 winters, and my ridge remains exactly as it should be. Mine, unmarred, offering unobstructed views of the mountains. I have built a simple bench up there, just a wooden seat where I can sit and think. No octagonal design, no decorative railings, no plaque declaring it community property. Just a bench on my land where I can watch the sun rise and set. Patricia Hendricks is gone from Meadowbrook Hills. George Pemberton eventually stepped down as HOA president after helping stabilize things, and life in the neighborhood continues. The gazebo that was built and demolished within a few months has become a cautionary tale, a reminder of what happens when authority exceeds its bounds and individuals fight back. I sometimes wonder if Patricia understands what she did wrong. Does she think she was the victim of an unreasonable homeowner and a biased judge? Or does she recognize that she violated fundamental property rights and faced appropriate consequences? I will never know, and ultimately it does not matter. What matters is that my property is my property, proven and protected. The hawk that circles my ridge in the evenings has become a familiar presence. I have started thinking of it as my hawk, though of course it belongs to no one. It rides the air currents, hunts the fields below, and lives free of boundaries and property disputes. There is something peaceful about watching it glide across the sky, utterly unconcerned with deeds and surveys and HOA regulations. This whole experience changed how I think about property and community. I still believe in neighborhoods and shared spaces and reasonable rules that protect everyone's interests. But I also believe more strongly than ever in individual rights and the importance of pushing back against overreach. Communities work best when they respect the boundaries, literal and figurative, that protect individual autonomy. If I could give advice to others facing similar situations, it would be this: know your rights, document everything, get legal help early, and do not be afraid to stand your ground when you are right. The system is slow and expensive and frustrating, but it can work if you persist. And sometimes, when the system fails to act quickly enough, creative solutions are necessary. Just make sure those solutions do not create bigger problems than they solve. The stacked materials at the HOA entrance might have been too far, but it sent a message that could not be ignored. I was serious, I was capable of taking action, and I would not wait forever for them to fix their mistake. That message, combined with mounting court fines and internal board pressure, finally forced the resolution that should have happened months earlier. Looking at my ridge now, restored and peaceful, I feel vindicated. The fight was worth it. The stress, the money, the confrontations, all of it was worth it to protect what is mine and to hold the HOA accountable for their actions. Property rights are not abstract legal concepts. They are fundamental protections that allow individuals to have security and autonomy in their own homes and land. The Blue Ridge Mountains stand eternal in the distance, indifferent to human disputes over property lines and gazebos. They will be there long after I am gone, long after the HOA is forgotten, long after Meadowbrook Hills is just another chapter in Virginia's history. That perspective is humbling and comforting. My fight mattered to me, but in the grand scheme, it was just another small human conflict over land and power and principle. Still, small conflicts matter. They define how we live together, how we treat each other, how we balance individual rights against collective needs. The gazebo incident was not about whether my ridge would have a nice structure on it. It was about whether the HOA could simply take what they wanted because they thought they knew best. The answer was no, and that answer protects not just me but everyone in the community who might face similar overreach in the future. As the sun finally dips below the mountains and darkness settles over my property, I feel grateful. Grateful for judges who uphold property law, for attorneys who fight for their clients, for neighbors who supported me, and for my own stubbornness in refusing to back down when I was right. The gazebo is gone, the HOA has been reformed, and my ridge is mine. That is all I ever wanted, and it is more than enough.